And one suspect on the list became important, and that was hydrazine. Hydrazine. Hydrazine.
All rise for the jury, please.
Come on in, folks.
The honor all members of the jury are present. Everyone, please be seated.
Appreciate it. Thanks so much. Well, welcome. Now I can call you our members of our jury panel. Welcome, welcome, welcome. I'm not even going to try my ish. I usually get at least through a few days of trial before I have to do the ish, but you can appreciate if you notice the council haven't left, right? So they've been diligently working, trying to minimize some of your time. And so while you had to wait, our apologies at the same time, trying to effectively make this the best possible trial and take the least of your time overall. So with that in mind, that's why I'm going to give you a heads up. Also going to give you a heads up is that, and you'll see, and you've already saw this during the voir dire process, different people may be coming in and out of the courtroom. Please pay no attention to that. You know, counsel, there's a lot of different things going on. I'm going to walk through some of the introductory remarks, okay? And then what we're going to do is after I walk through these introductory remarks, we're going to start with opening statements, and I'll get to that in just a second. So, first off, did anyone violate the court's admonition last night? If so, please raise your hands. No hands are raised. Perfect. Thank you. Okay. So, a couple of the ground rules that you heard during the voir dire process, but they're so very important, I just want to repeat them to you. First, as you probably have heard multiple times, you must base your verdict solely on the evidence presented to you in the courtroom, not on anything you may hear from anyone else or anything you may hear from any outside information you may have, etc. You are admonished that no juror may declare to a fellow juror any fact relating to the case of his or her own knowledge, and if any juror discovers during the trial that, or even after the beginning of deliberations, that he or she or any other juror has personal knowledge of any fact or controversy in this case or any witness, please present that to the marshal. The marshal will then let the court know. I will then touch base with the attorneys and we'll address what needs to be done. So what happens, it rarely happens, but sometimes, guess what? Someone comes up on the stand and guess what? That's your neighbor. You didn't recognize their name, or you know what? But they, you know, and so it's an issue. Just let the marshal know. We get that taken care of. We mentioned earlier during the course of the trial, the attorneys for both sides, the parties, the witnesses, and court personnel, other than the marshal, are not permitted to converse with members of the jury. So that means if we see you either, whether out in the hallways, in an elevator, in a parking lot, may go in a different elevator, you know, if you see even outside, like I used the grocery store, I know example, during the voir dire process, don't be offended, you know what I mean, if you go get a fruit or vegetable instead of being in the frozen food aisle. And it's really to protect, to ensure that you're fair and impartial. Everybody understands that, right? Okay, perfect. Thank you so very much. Okay, so now I'm going to tell you what's going to serve as just a brief introduction to the trial in this case. It is in no way a substitution for the detailed jury instructions on the law which will be given at the conclusion of the case before you retire to consider your verdict. This is a civil case. A civil case is commenced by plaintiff or plaintiffs, in this case, against defendant or defendants, in this case. The case is based on a complaint filed by the plaintiffs and served upon the defendants. The defendants then have an opportunity to file what's called an answer to the complaint, which they admit certain allegations, deny other allegations. And this trial will be about those disputed issues. And you'll hear that there are certain agreements or certain court rulings that's going to impact some of the issues that are actually going to be present in this case. Do counsel waive the formal reading of the pleadings?
We do, Your Honor.
Real water?
Yes, Your Honor.
Yes, Your Honor.
ETT?
Yes, Your Honor.
Okay, well, you're glad about that. That means I don't have to actually read the whole complaint and answers and different pleadings. And once again, it's very counsel in order to from a time-saving standpoint. So ladies and gentlemen, okay, whoever is coming on remote, you must immediately mute yourselves. We are in the middle of a trial, please. This is a public courtroom. We are more than happy to have you have access to a public courtroom, but you do need to comply with the rules. Please see ADKT 613, Rules of Professional Conduct, and other rules with regards to remote observations. Thank you so very much, to the extent any of those apply. Thank you. Okay, so we're going to try and minimize those during the trial, but you can appear with it, since we now in the modern age have both remote and people in person. Sometimes that may happen, okay? We hope you don't have to go toilet flush in the middle of your case, but sometimes it happens. We try to minimize as much as possible. Going back to actually the structure of the introduction, we need to make sure you clearly understand that the pleadings in this case are not in any sense evidence of the allegations they contain. Each party has the burden of proving their respective claims by what's called a preponderance of the evidence. And you recall, people utilize my little scales from sorry, Liberty 1, this is now Liberty 2, okay? Explain to you the preponderance of the evidence. I think there was a reference to like a fed, or sometimes people say a little bit more than 50%, et cetera, okay? So that is very different than the criminal standard. Does everyone understand this is a civil case and we need to use preponderance of the evidence? Okay, do appreciate that. So the purpose of the trial will be about the disputed issues in this matter and whether the parties will meet their respective burdens. It's your primary responsibilities as jurors to find and determine the facts. Under our system of justice, you are the sole judges of the facts. You are to determine those facts from the testimony you hear and other evidence, including exhibits that are introduced in court. It is up to you to determine the inferences which you feel may be properly drawn from the evidence. Parties may present sometimes what's called an objection. You already heard that during the voir dire. The objection is somebody representing their particular client when they feel that they need to set forth something for purposes of the record. The court will either overrule, or it will sustain an objection, or it may be withdrawn. If the court overrules the objection, then the witness can answer the question. And if the court sustains the objection, then the question either needs to be rephrased in some manner and the witness cannot answer it. If the objection is withdrawn, then the court doesn't make a ruling. Oftentimes you'll hear, and you heard this during voir dire, sometimes a question got rephrased. We're going to walk through in just a moment is because in this case you have that wonderful opportunity of not only having some live witnesses, but you have some video witnesses, okay? And so that process is oftentimes, part of it is done for the video witnesses. And when I say video, there'll be actual videos of prior depositions and some other formats. Some of those objections have already been addressed in an earlier stage, okay? I'll explain that a little bit more when we have some of those witnesses so everybody understands. Now, you can't take into account whether or not a party raises lots of objections, very little objections, or no objections. Each counsel needs to determine for their respective parties how many objections they need to make, okay? And so the court just needs to rule. Now, of course, you have to listen to the court's ruling. The witness does too, and either answer or not answer the question depending on the court's ruling. But the number of objections can't be taken into account. Similar, like you can't take into account if people are here during the entire trial, or not here during the entire trial, or they need to leave at different times. Everybody understands that? That's kind of a point sometimes question comes up. Okay, very important. Also, you need to make sure that you're not influenced in any degree by any personal feelings of sympathy for or prejudice against any of the parties. All sides are entitled to the same fair and impartial consideration. And this was explored a lot in voir dire, and you all asked all about that. Appreciate your answers there too. In considering the weight and value of the testimony of any witness, you may take into consideration the following: the appearance, the attitude, and the behavior of the witness. You may take the interest of the witness in the outcome of the case, if any, the relation of the witness to the plaintiff or either of the defendants, the inclination of the witness to speak truthfully or not, and the witness's statements, and all of the facts and circumstances in making that determination. Thus, you may give the testimony of any witness just such weight and value as you believe the testimony of the witness is entitled to receive. There's two types of evidence, and that was kind of gone over a little bit in voir dire, but I'll go over it again. There's direct and circumstantial evidence. Direct evidence is testimony by a witness about what that witness personally saw, heard, did, felt, touched, etc. Circumstantial evidence is testimony or exhibits which are proof of a particular fact from which, if proven, you may infer the existence of a second fact. It just rained the other day, so this is my perfect example of direct and circumstantial evidence. If you were outside and raindrops were falling on your head, right? Direct evidence, it's raining. If, however, you were nicely in your house watching whatever you're watching or doing whatever you're doing, and you hear this little pitter-patter noise in your ceiling, and you're assuming you don't have something crawling around in your ceiling that you'd rather not have crawling around in an attic, right? And also, to give my fact, say you just nicely polished your car, it's beautifully done, and you walk outside and there's little droplets on your car. That would be circumstantial evidence it's raining, right? Both the pitter-patter you're hearing in your attic/ceiling, as well as what you view are droplets on your car. I'm presuming in my example that you have drought-tolerant watering, right? And so you don't have sprinklers that went off. Okay, circumstantial evidence raining. Everybody understands direct and circumstantial evidence? Okay, thanks very much. Now you can consider both direct and circumstantial evidence, and because something is direct or circumstantial doesn't mean that you give one more weight than the other. You get to determine the weight you give both to direct and circumstantial evidence. So opening statements and closing arguments of the attorneys are intended to help you understand the evidence and apply the law, but they themselves are not evidence. You must not speculate to be true any insinuation suggested by a question asked the witness. A question is not evidence and may be considered only as it supplies meaning to the answer. Until this case is submitted to you, you must not discuss it with anyone, even your fellow jurors. After it's submitted to you at the time of jury deliberations, you must discuss it only in the jury deliberation room. It's important that you keep an open mind and not decide any issue in this case until the entire case has been submitted to you at the time of jury deliberations. If at any time you can't hear a witness, you can't hear counsel, raise your hand, and the marshal will come over and get that taken care of for you. Please also raise your hand. We take breaks about every 90 minutes. You saw during the voir dire process, right? That was so quick that we take breaks at different times. So if you need anything more, if somebody needs an accommodation, let my marshal know and get you taken care of, okay? No statement, ruling, remark, or comment which I may make during the course of the trial is intended to indicate my opinion as to how you should decide the case or to influence you in any way on your determination of the facts. At times, I may even ask a question of a potential witness. If I do so, it's for the purpose of bringing out certain matters which I feel should be brought out. It is not in any way to indicate the opinion of the court or which facts or how much you should give weight to said facts. You, as the trier of facts, get to determine that. During the trial, you may see me take notes. During the voir dire process, you probably saw me busily taking notes on my computer. In addition to having my full attention in this case, you can appreciate about 700 other cases, which means thousands of other matters currently on my docket. So you can appreciate I need to be fully prepared for everything. So I do a lot of different things, okay? And everybody understands, don't take it if you see me taking notes or being on my computer. You can really disregard that. You do have to answer, listen, like I said, if I make a ruling on an objection. But everyone understands that, right? Okay. So, the jury will be furnished with notebooks. You already have your notebooks. Let me explain real briefly the purpose of the notebooks. Well, one of them we already addressed, right? For people to write down the anticipated schedule for the trial. One of the other reasons for the notebooks is here in Nevada, jurors can ask questions. But what you do is you don't ask questions like the counsel do. You don't ask them verbally. What you do is you write your last name, your badge number, and for purposes, because we've had a little bit of issues because of the change in the jury system, you also just write your seat number, okay, on it, and you would write down the question. And then that question may be answered at the end of the witness's testimony. So how that does is you write your name, your last name, your badge number, like I said, also your seat number, and then you write the question, okay? Then we ask it really to kind of put at that front little bar, okay? The marshal will at different times take it. Now, I will tell you, jurors are not required to ask questions. You just have the opportunity if you wish to do so. We have some trials that very few or no questions are asked, and we have others that a lot of questions are asked. I will also tell you in advance, do not be offended if your question is not asked. There's a variety of different reasons from legal bases that certain questions can't be asked, okay? So know that in advance. The other thing that's very important is you can't ask a question if a witness is already gone. You have to do it while a witness is on the stand. So, for example, if a witness were to testify tomorrow, and all of a sudden you think of a question next week, you can't call that witness back to ask that question, okay? There's also a little bit of a challenge when we have certain people that are just appearing by video that are not live witnesses, meaning there's only excerpts of their video deposition that's being presented. That presents a different challenge for questions as well, okay? And I'll go into that, like I said, when we have those witnesses being presented, so we'll talk about that a little bit more. With regards to those questions, like I said, what happens, the general process is counsel, whoever's the witness is being called, has an opportunity to do their examination. That's called direct examination. Any of the other parties can do the cross-examination. After they've completed their cross-examination, and by agreement of the parties, there will be a particular order in the cross-examination, so each of the two defendants have an opportunity for certain witnesses to do cross-examination. Then counsel, or if in this case it was plaintiff's witness, plaintiff would then do redirect examination, then there can be recross, the same thing until all the questions have been asked for a witness. Once that's concluded, we do see if there's any juror questions to be asked of that particular witness. Oftentimes we may just discuss that briefly at bench. You've already heard the white noise, okay? But it's the type of issue that may take a little bit longer, same thing as we did during the voir dire process. They send you out so you're not just sitting here, okay? And that's the way we handle. So that's one of the important things with regards to the notebooks. The other thing is the practical aspect. You're welcome to take as many notes as you want. As you will notice, since the pen issue of yesterday, there should be a nice, right, red Solo cup full of pens, Marshall?
Right there next to the pictures, Judge.
Right in the pitcher of water, okay? So you now have a plethora of pens in case you need it. We also do as many juror notebooks as you need. We do ask that they be remaining in the chair each night, and the marshal will ensure they're there for you the next morning. So you can take as many notes as you wish, okay? And that's the other purpose for the jury notebooks. So the trial will proceed in the following manner. First off, everybody clear on juror notebooks? Any questions? Okay, we're good for that? Thank you so much. Okay, the trial will proceed in the following manner. The plaintiff's attorney will make opening statement, which is an outline to help you understand what the plaintiff expects to prove or plaintiffs expect to prove. Since we've got a variety of different plaintiffs' counsel, you'll hear opening statements probably by at least 2 of the plaintiff's attorneys, okay? And they give those outlines. Now remember, opening statements are not evidence. They would be an outline of the information. After plaintiffs have an opportunity to present their opening statement, each of the defendants have an opportunity to present their opening statements. After the opening statements are concluded, plaintiff then calls the various witnesses that they wish to call. As I went over a moment ago, the questioning first, if plaintiff is calling a witness, they get to examine that witness first, and then cross-examination by each of the defense counsel, and then back to redirecting back and forth to all those questions. I already went through juror questions. After the plaintiff is rested, then each of the defendants has an opportunity to call their witnesses in their case in chief, and then they would examine that witness first. Plaintiff would do cross-examination, the other defendant has an opportunity to do cross-examination, and we go back and forth in the same process. After each of the defendants have completed their questions and their cases in chief, then each of them rest. After they've rested, then plaintiff has an opportunity to do what's called a rebuttal case, and there's some other processes that will happen, and we'll explain that a little bit down the road. So, at that juncture, that kind of gives you a general outline of the case. After all the testimony has been concluded, then we'll have closing arguments. Closing arguments are a summation from each of the parties of what they think has and has not been proven, and you can evaluate that as such. Closing arguments, like opening statements, which I said a moment ago, are not evidence. They're just an outline of what they think has been established. And then we'll address any other issues that come up during the trial as we get a little bit further during the trial. As I mentioned before, sometimes I may call counsel up to bench to try and efficiently do something at bench. That's when you hear the white noise during voir dire. We're doing that. Other times we need to excuse me, I already walk through that. After all the closing arguments and everything's done, then the jury goes back to deliberation, makes a well-reasoned verdict. But actually, before we get to closing arguments, I mentioned the law, the jury instructions. So after the close of evidence, actually before we have the closing arguments, the court instructs you in the law in the case, okay? And there will be detailed jury instructions, and by the way, the court will need to read those word for word to you, which you will be provided in the jury deliberation room, a copy of said jury instructions. Those jury instructions are the law of the case. You as the jury are the triers of fact. I as the court need to establish the law. And so I'm going to make some legal rulings, and then you'll get the jury instructions. And it was your obligation to follow those instructions of law when making your well-reasoned verdict. Okay, so end of evidence, jury instructions, closing arguments, and we will address if other processes come forward a little bit later in the case. So a couple things to remind you, as you've been told over and over, please ensure that you do not talk about the case with anyone else. Please don't try and talk with any of the counsel, any of the witnesses, or et cetera. They've all been instructed not to talk to you and nobody's being rude. Please don't take into account if people having to come in and out of the courtroom. And please just focus on all the evidence, keep an open mind until the conclusion of the evidence when you make your well-reasoned verdict. In this regard, the court has gone through the general structure. What I do now is I just check with each of the counsel to see if they're ready for opening statements. Yes, okay, so as we noted, counsel for plaintiff has an opportunity to go first with their opening statements. Just to let you all know, we let counsel with their opening statements. They can either be at their desk, they can be at podium, they can be at smaller podium. Many times they like to walk around, and they can walk around to what's called the well, which is the front here, and point to various things. So counsel for plaintiff, feel free to commence with your opening statement.
You need this turn, counsel? Okay. Okay.
And I will tell you in advance, there will be times, because when people use pocket microphones, just like you saw with the big microphone, the batteries run out, and we may have to stop and pause, so please, no worries in that regard.
Good morning, ladies and gentlemen. If you don't remember, my name is Will Kemp, K-E-M-P. And together with Mr. Pepperman, Mr. Pepperman, we, Mr. Parker, represent the 5 plaintiffs in this case. So, as the judge told you, we're doing the opening statement now. So I'm going to be starting, followed by Mr. Parker, followed by Mr. Love, followed by Terrible Herbst counsel. Okay. And as the judge said, the opening statement is intended to be an introduction to the facts of the case. What I say is not evidence. What anyone says is not evidence. We're just trying to outline the evidence for you now. So think of it like a movie or a book. I'm just trying to give you some of the key events that you're going to hear about in the case. Okay, this is a case about acute liver failure. Acute is a word that means suddenly, rapid onset, comes on quickly. Acute liver failure. It's up there on the screen. You will hear the term acute liver failure hundreds, if not 1,000 times in this case, because this was the injury the 5 plaintiffs in this case suffered. And before introducing you to the 5 plaintiffs, I want to talk briefly about acute liver failure and how the acute liver failure outbreak was discovered by the government officials. This is the liver. This is where the liver is in the body. The orange represents the liver. Can we see the next one, Shane? Here's the liver with the stomach underneath of it. Same concept. So the liver is one of the most important organs of your body because this is what the liver does. Shane? So it does 500 different functions, believe it or not. And some of the critical functions are detoxification, it cleans the blood, and it processes proteins and biochemicals into the blood. And if you do not have a liver, you do not live, okay? And the reason for that is your blood will no longer properly clot, toxins and chemicals will build up quickly in the blood, defenses against infections fail, and you start having swelling, including swelling of the brain, which is called encephalopathy. And as we're going to get into in a little bit, some of the plaintiffs in the case had the encephalopathy condition. Now, acute liver failure is a critical medical condition. My next one, Shane. So you have near complete loss of liver function that happens rapidly. It happens in days or weeks. It's not over years like you hear about some people with liver disease. This happens in days or weeks, and usually it's in persons with no pre-existing disease. Next one, Shane. So it's a medical emergency. When you have acute liver failure, they have to take you to the hospital rapidly. Usually they put you in intensive care, and as you'll see, at least 4 of the 5 plaintiffs in this case did go to intensive care. Next. Acute liver failure means the liver stops working, okay? It doesn't just work poorly, it stops. And that is why you have the toxic buildup so fast. Next, Jane. So it causes serious complications. These are some of the symptoms. I'm going to show you a chart a little bit that has more of the symptoms. But extreme fatigue, jaundice, you get yellow, loss of motor functions, bleeding, loss of consciousness, increased pressure in the brain, which I told you about. 20% of the people that get acute liver failure ultimately die. Fortunately, none of the 5 people in this case died. Next, Shane. So here are the plaintiffs. I've said there's 5 people in this case. This is the first plaintiff, Mr. Hunwardsen. He's back there, Myles. Okay. The second plaintiff, this is Mrs. Brody. Mrs. Brody. Okay. Third plaintiff, this is Jasmine. She's right there. Fourth plaintiff is Tina. And then the 5th one is Christina Sosa, which is Mr. Parker's client. So Mr. Parker is going to tell you more about Christina Sosa. All of these plaintiffs had acute liver failure. Let's start out with Jasmine. Here's a picture of her. She is a flight attendant for Southwest Airlines, President. She had acute liver failure on November 15th, 2020. 29 years old when she was hospitalized at Spring Valley Hospital, and she had unbelievably high liver function tests. Now you ask me, what's a liver function test? A liver function test is a test that the doctors use if they suspect there's a problem with the liver. So it's a group of blood tests that helps to show the extent of liver damage. We're going to be talking about 2, Shane. So ALT and AST, there's really long medical terms for ALT, that's an abbreviation, but for our purposes, let's just use ALT and AST. Those are the 2 most common done. So a normal ALT is 12 to 78. So the top figure is the important one. Anything higher than 78 for an ALT is abnormal. Okay? Normal AST is 27. Anything higher than 27 for an AST is abnormal. So plaintiffs that have acute liver failure, where their liver stops working suddenly, they usually have very high ALT or AST results. Next one, Shane. Next. This is a medical record for Jasmine from the hospital. So when she went into the hospital, and first she went to urgent care, attempted to be treated there, and then she went to the hospital. So at the time she went to the hospital, she had already had 4 weeks of abdominal pain, occasional vomiting. The workup showed elevated ALTs and AST. Those are the 2 liver tests. Let's see the ALT, Shane. Okay. Oh, back, please, Shane. I'm sorry, I missed one. Nauseous constantly, vomiting at least twice every day. These are classic symptoms of acute liver failure. Next. So I told you that the normal ALT was 78. She had 1,306. The normal AST being 27. You know, I might have gotten those backwards. But in any event, look at these levels. These are amazingly high. 2,685 on November 14th. The day before, 3,637. These are incredibly high liver function tests. And based on these, and based on her symptomology, the doctors diagnosed acute liver failure. Okay. Next plaintiff, same situation. The doctors said drug-related injury. They didn't know what the drug was, but I'm going to tell you shortly. Go ahead, Shane. So we're going to move on to Tina. So Tina was a cocktail waitress at the time she was hospitalized, working in the pool area, swimming pool area of a hotel, drinking lots of water, real water. Next, Shane. So Tina was in such bad condition that when she went to the hospital, she couldn't even give a medical history. All she could do is say yes or no. They had to take the medical history from her family. Next, Shane. So once again, look at these AST levels, 2121, ALT 1375, extraordinarily high, especially for young people, for a relatively young person. And by that I mean anyone under 60 or 55, because that's usually when you see the liver disease. Next, please. So she was drinking 3 liters of alkalized water per day. That's the real water. Documented in the hospital records. Again, she's drinking a lot of it because she's out in the swimming pool in the heat. Next, please. So what are the treatment options when you have acute liver failure? There's only one thing they can do for you. Either you get better on your own, or you can do a liver transplant. They take the liver from a stranger and they put it into you. That's what a liver transplant is. So that is the treatment option for acute liver failure. And that is a very complicated operation. I'm going to go through it in a second in some detail from one of the medical records of one of the plaintiffs. But that operation is not even done here in Nevada. You cannot have that done in Nevada. You have to fly to a special transplant center. For children, they go to Children's Primary Hospital in Utah or Denver. Yeah, for adults, they go in California, either UCLA, USC, or Stanford. But this is such an intensive operation. It lasts from 4 to 18 hours, and you have to have a very highly trained liver transplant team. And in this case, you're going to hear testimony from 2 doctors, well, at least one, our doctor. I don't know if they're called their doctor. But you're going to hear testimony from a liver transplant doctor that actually does this operation. And he's going to explain the details to you. So after the operation, after you have the new liver put in, if you're lucky enough to get one, because there's a waiting list for livers. So if you're lucky enough to get one, you have to take what is called an immunosuppressive drug. All that means is it's an anti-rejection drug. Remember I said this is a stranger's liver they're putting in you. They don't match it up. If you're lucky enough to get the liver, you get the liver from a stranger, so the body attacks that. It's a foreign substance being put in your body. The body attacks that. So to stop the attack, you have to take anti-rejection drugs for the rest of your life. And I'll get into that more. Usually the person survives And the plaintiff in this case that had the liver transplant did survive, but there's a 10 to 15% failure rate. There's a 58% chance of surviving 15 years. Next, Shane. So let's talk about Mrs. Brody for a minute. Mrs. Brody lives in Henderson. She was drinking real water. She started getting ill, same symptoms that I've told you about before, fatigue, vomiting. So she went to the emergency room of the Henderson Hospital. Okay, Shane, can I have the next slide? These are the actual records. She was 78 at the time. So she's flushed, tingling, dizzy, about to pass out, vomiting, same symptomology as everyone. The only difference between Mrs. Brody's case and everyone else's cases is that for some reason, the doctors in Henderson didn't give her an ALT or AST test. So we don't have a score for her, but we know she had acute liver disease because she had the exact same symptoms. Again, this had been going on in her case for weeks. So she goes to the emergency room, they keep her there for a while, and then she goes back in, and she's been passing out for 2 to 3 months, tired, loss of consciousness. Again, these are all classic symptoms of acute liver failure. Next, Shane. Oh, these are her symptoms: dizziness, vomiting, cramping, nausea, fainting or passing out. You will see, I'm going to show you a chart from the Southern Nevada Health District in a little bit. Classic symptoms. Next. This is Christina Sosa. As I indicated to you before, that's Mr. Parker's client. Mr. Parker and I both represent Mr. Hunwardsen. He represents Ms. Sosa. So he's going to tell you about her damages in his section. Next. Myles. I'm going to tell you about his damages in detail shortly. But basically, all you need to know at this point is they flew him to UCLA, and he had a liver transplant. He's the one plaintiff that had to actually have a liver transplant. Next, please. Next. So, why did these people get acute liver failure? That brings us to real water. So, I want to explain briefly the real water manufacturing process. Okay? So, here's what happened. In the fall of 2020, 5 children, babies actually, 5 children were transported from hospitals here in Clark County because they all had acute liver failure. Remember I told you about the hospital in Salt Lake, the one for children? They flew all 5 of them, separate jets, they flew all 5 of them to the Salt Lake hospital within the course of a couple weeks. And they all had extremely high ALTs and ASTs, same situation as the plaintiffs. And so these were young people. Some of them were 6 or 7 months, some of them were 2 years, some of them were 3 years old. They were very young, the 5. They were all treated by the same transplant doctor in Salt Lake. His name's Dr. Guthrie. So Dr. Guthrie said, wow, this is really unusual that I would have 5 young children from the same community come within the course of just 1 or 2 weeks, when usually we only see 1 or 2 people in the whole country at this age. So he knew something was up. So what he did is he called up the Southern Nevada Health District and told them what had happened. And so the Southern Nevada Health District started what they call an exposure assessment. They interviewed the families of the 5 children, and they said, well, where do you live? What do you drink? What do you eat? You know, tell us about your life. And they found that all 5 children had one thing in common. They all drank real water. And that was the start of the investigation on real water. So, in the United States, we have the CDC slides, Shane? Okay, I think you skipped one on me. Anyway, in the United States, what happens when you have an outbreak like this is you have 2 federal agencies and 1 local agency do the investigation. So in this case, we had the CDC come in here, the FDA come in here, and they assisted the Southern Nevada Health District in the outbreak investigation. Okay, they're trying to find the cause. There's the titles. The CDC really investigates the disease outbreaks. The FDA provided, in this case, backup support, a lot of laboratory testing that I'm going to show you in a second. And then the Southern Nevada Health District kind of coordinated it, did all the interviews. But anyway, they came in, they did the investigation, and as part of the investigation, the Southern Nevada Health District wanted to find out what is the background rate for liver injury in Clark County. Do we have more injuries? You know, in the last, they went back to 2016. Have we had more injuries in 16, 17, 18, 19 that we don't have an explanation for? So the Southern Nevada Health District has the ability to automatically access all the computers in all the hospitals. So I think they're still over there in Shadow Lane, but they can, through a couple keystrokes, just get all what's called the diagnostic codes. And that's where I think you want to go, Shane. So these are the diagnostic codes for liver disease. So what this health district did is they went in each hospital here in Clark County, they said, tell us all the liver cases you have that you do not have an explanation for, okay? And they wanted to look for a pattern. And here's what they found. They prepared this chart that was published in what's called the MMWR. That is the Morbidity and Mortality Weekly Report. It's a publication by the CDC. So you will see that the baseline here is probably right about 8. So we went back to 2016. So you see they're getting more cases than you would ordinarily expect of acute liver failure in Clark County. And you see how in November 2020, there's this big spike. That's what we call the outbreak. You'll hear that called the outbreak in this case, the 2020 outbreak. So that involved a number of patients. Some of the people in here fall in 2020 cases. But the CDC and the Southern Nevada Health District went in, they interviewed all these people, and they determined that they had acute liver failure. Next, please. So what caused this acute liver failure? What is the cause? Well, first of all, let's go back to common signs. I told you I'd show you the chart from the SNHD earlier. This is a chart that the Southern Nevada Health District prepared that has all the common signs of liver failure. Because like Mrs. Brody's case, sometimes people don't get their ALT, AST measured. Nausea and vomiting, convection, dizziness, weight loss, vision problems, all these things all 5 plaintiffs have. So the CDC, the Southern Nevada Health District, had a list of suspects. So they determined early on that it was caused by some toxin, but they didn't know what it was. So here are some of the suspects they started out with. You know, the second one up there is acetaminophen, that's just Tylenol. But these are all the suspects. And one suspect on the list became important, and that was hydrazine. 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 Okay, next shade. So the Hydra was a mythical monster in ancient Greece that had 9 heads and lived in the swamps of ancient Greece. That was the Hydra. And if you remember the movies, or maybe you read the book, Hercules finally slays the Hydra by cutting off all 9 of its heads. So this case involves hydrazine. And I explain this to you just so you can remember the chemical. Next shade. So what is hydrazine used for? Hydrazine was used as rocket fuel to launch the rockets that went to the moon. Hydrazine. Hydrazine is still used today to launch rockets. This is a SpaceX rocket. Actually, this is kind of a hydrazine blend that Elon Musk uses, but it's still hydrazine. So hydrazine's primary use is rocket fuel. And I'm sure you're wondering to yourself, how could rocket fuel be involved with bottled water? Hydrazine, and the reason you ask that question is hydrazine is toxic. Because it's been used by the government for so long, they've done a lot of tests on hydrazine. They've tested it on monkeys, dogs, guinea pigs, 3 or 4 other types of animals, and they found out that hydrazine causes acute liver failure. There's a lot of information as to dosing, how much hydrazine it takes to cause acute liver failure, a lot of information about it. Next, Shane. So, to explain that information to you, we are going to present to you the testimony from one of our experts by video, Dr. Kosnet. Dr. Kosnet is what they call a toxicologist. So a toxicologist is a science that studies the reaction of human toxins on the body. Anything from hydrazine to alcohol. Anything you put in your body, they study what happens to you. He's a board-certified toxicologist from Colorado. And he's going to talk about the scientific literature. Remember I told you there's a lot of testing by the government? There's lots of papers on hydrazine toxicity. And he's going to explain that hydrazine causes acute liver failure if it's consumed by human beings or animals. So, why is it I say that there's hydrazine in real water? Because the CDC went and did some testing. And here's what the CDC found. Again, the CDC, Center for Disease Control. So they went out to the real water plant and they took samples. And they took the samples, they were actually tested in the the FDA laboratory in Cincinnati. That's where they do a lot of this testing. And so when they tested what's called real water concentrate, let me back up for a minute. This is a 5-gallon jug that actually came from a real water plant that they put what they call concentrate in. I'm going to get through the manufacturing process in a minute, but for now, they made concentrate, which is a concentrated formula. Then they poured it into water, and that's how they made the real water. So the concentrate is the first thing they made, and that's what the FDA focused on and tested. So the FDA came out, and they took samples from the real water plant, and then they took it back to Cincinnati and tested them, and they found the concentrate. Now, if you take a look at the levels, and again, Dr. Kosnet's going to explain this to you, they found 1.44, 1.75, and then they did a third test. So they did 3 different tests on the concentrate, and they find 1.33. These are extraordinarily high levels of hydrazine to be in any type of liquid, much less a bottle of water. So FDA did the testing. Next, Shane. And then we had additional testing done in the litigation. Additional testing was done on the actual retail bottles. You'll hear a testimony that Myles drank retail bottles from Terrible Herbst. So testing was done on the actual retail bottles that were produced by real water. And that testing also confirmed that there was hydrazine. So the FDA tested the concentrate. There was testing done on the retail bottles. No dispute that there was hydrazine in the real water. Next, Shane. This is just a picture of a real water bottle. Okay, they get blue's their thing. They like to be nice and blue. Next. So now I'm going to try to explain the real water manufacturing process. The real water manufacturing plant first was on Desert Inn, right over there in the industrial area where Desert Inn Desert Inn's kind of a screwed up street. It doesn't go straight through anymore. They built the overpass and then you can get off in Desert Inn. So the manufacturing plant was kind of right where that place called Area 15 is. I think that's the name, right? Area 15. So that's where the manufacturing plant was. This is how they made the product. Next, Shane. And this is a chart that I'm going to go through real quick. And don't feel like you have to get this all up front. Remember, this is the movie. I'm just telling you what's coming up. This is going to be explained in a lot of detail, all right? So here's what they did. They took purified water, so they just get water from Lake Mead, they run it through a filtering system, and they create purified water. So that's the first step. Then they take the purified water, and they run it through these titanium tubes, which, Your Honor, I forgot to ask where the, thank you, Your Honor. These are the 2 actual titanium tubes, and since they're actual evidence, they're the court's possession, not mine. So what happened is they run the water through the tubes. Okay, there's 2 tubes. The water's run through both of them. And then they electrolyze the water. And what I mean by that is they hooked up battery cables, just like you would use for your car, and a battery charger, and they have a constant electrical charge going into it. So they first they put some chemicals in it, and the reason they put chemicals in is If you have purified water, that can't contain an electrical charge. So in other words, if we just juice purified water, it doesn't retain a charge. You have to put a solid in there to catch the charge. So first they put some chemicals in, then they juiced it, then they subdivided it, then they juiced it again. Then the third thing they did is that made the concentrate, that made this, and then they took the concentrate and they mixed it with more purified water in these big 300, 400 gallon tanks they had. And then after that, they used a measuring device to make sure it was where they wanted to, and if it wasn't, they dumped in more concentrate. So, juice, mix it up, and then measure it to make sure it's where you want it, right? Now, this was alkaline water, so they wanted it to have a negative reading. So their target reading was negative 250, I think. But anyway, they wanted it to be negative, and that's why they had to do some measurements to determine that they reached that. All right, Shane? So these are the titanium tubes. These are the actual ones that they use during the manufacture. And you ask yourself, well, how did it come about that they were making water like this? I mean, where did they get this idea? Next, Shane. This is just the stand that held the titanium tubes in place because they were dumping water from the top and gravity was coming through the tubes and it's coming out. So they had to hold the tubes in place with something. So they used this thing. See how those little clips there to attach to the tubes. Next, please. And I told you that they were juicing it with something that looks like a car battery or it's battery charger. This is the actual one that they used. These are the clips that they used, and again, the clips were attached to these tubes, so juice. Next. So, how did this result in the formation of hydrogen? How did this process make rocket fuel? All right, we're going to call as one of the witnesses. In fact, I think he's going to be here tomorrow. Tomorrow, Friday. You know, okay. If tomorrow's Friday, he's going to be here tomorrow. All right. So, his name's Dr. Najim. And Dr. Najim has a doctorate degree in environmental engineering. He wrote the 2 leading papers in the world on hydrogen formation, how to make hydrogen. So he is the world's leading expert on hydrogen formation. Next, he's going to explain this 4-part process. I actually stole his chart. This chart came from something that he prepared. So it's the same thing I just got done doing. First they juice it, then they juice it, then they do the concentrate right there, and then they mix it up with the rest of the water to make the final product. So when they juice it, they start out with 300 gallons. And remember, it's alkaline water. They're trying to make alkaline water, so they got to separate the acidic out of it, right? So when they juice it, they divide it. One goes one way. If I could cut this open for you, there'd be a little diaphragm in here, and that allows the acidic to go one way and the alkaline to go the other way. So what they do is they dump 300 gallons in through the tubes, and then they throw away the acidic, and they keep the alkaline. So now we've subdivided once. That's 150 gallons. Then they repeat the whole process, make 150 gallons into 75 gallons. Okay? And then they take that and they store that, and that is the concentrate. And the concentrate was a top secret component in the real water manufacturing process. They had a room that was called the concentrate room. And only one person, well actually 2, Blaine Jones and the inventor of this process, who I'm going to discuss in a minute, only those 2 people were allowed to go into the secret concentrate room. Only Blaine Jones was allowed to make the concentrate. And who is Blaine Jones? The real water facility was owned by his father, Brent Jones, and his stepmother, Amy Jones. So Blaine Jones was the son that was actually assisting in the operations of the facility. And since it was such a secret process, only the son of the owner was allowed to do it. He was the only one that made the concentrate. Okay, next, Shane. Again, this is just, okay, we go from 300 to 100. and then we mix it up, then we do the testing. So this is a complicated chart explaining what I tried to do with juice. So he's gonna go through this for you in detail, all right? And he's gonna tell you that there could have been 10 times as much hydrazine as there was when the FDA did their measurements. Because remember, the FDA took these samples in March of 21, and then they did the actual testing in October of 21. So you have a little degradation during that time period. The hydrazine goes down a little bit. So he's going to explain there could have been more when they actually made the product. Next, Shane. So this case, Mr. Odou is going to explain to you that they've admitted they're liable for compensatory damages. Okay, Real Water has admitted liable for compensatory damages. So they're not saying, oh, we're not liable, you have to find us liable. Okay. So the two big issues in the case involving Real Water are, one, the amount of compensatory damages for each plaintiff. That's the first issue. And then the second issue is whether or not they're liable for punitive damages. Okay? And I should explain, people are looking at me like they're starting to be hungry. The judge has asked that I stop at 12:15, no matter where I am. So 12:15, we're going to lunch, okay? Okay, punitive damages. We are going to argue that Real Water is liable for punitive damages for a couple reasons. One, so the product was developed by this fellow named John Marlowe. He's an elderly gentleman. He's going to come in, testify live. He still lives here in Vegas. So to come up with this product, he kept changing the formulation of the concentrate, mixing it up, and then he would test it on himself. He would drink it, and if it made him vomit, he'd change a little bit, and if he didn't feel sick, you know, he self-tested this product, used himself as a human guinea pig. And you would think a brand new product should have safety studies. Absolutely no safety studies done on the final product before it was put on the market. None whatsoever. In addition, we're going to prove that they did not follow standard water bottling safety procedures. And you know, I don't want to spend a lot of time on that because Dr. Najim and some of the others are going to get into that. Next. So there were a lot of safety violations. And there was actually an audit company that was hired by Costco. Costco, they conduct what's called a third-party audit on each and every product sold at Costco. So you buy a cookie at Costco, that manufacturer is subject to a third-party audit. You buy a bottle of water at Costco, that manufacturer is subject to a third-party audit. So Costco hired a third-party company to come in and check and see what is Real Water doing. So in 2019, the inspection entity, it was called NSF, that's the third-party auditor hired by Costco. They went in there in December 18, and they found all kinds of violations by Real Water. Next, Shane. I'm sure the violations in a second. So the other problem here is we talked a lot about customer complaints. So Mr. Odou kept asking you, you know, what would you do if you give the customer a free brownie or whatever? So the reason he did that is because they didn't document or investigate customer complaints. Their solution, anytime a customer complained, was to have the receptionist give the person who complained free water. That was the solution. And you're going to hear that testified to by a number of people. So instead of documenting or investigating customer complaints, they minimized customer complaints. And we're going to show you customer complaints. I don't want to get into them all now, but we're going to show you customer complaints going back to 2014. We're going to have some people actually who complained come in and testify to you about the complaints they made, some of which was acute liver failure in hospitals here in Clark County in 2018. That was one of the customers' complaints we're going to tell you about. So they just ignored these complaints. And then the vice president, remember I told you about Blaine Jones? Okay, Blaine Jones was the vice president of Real Water. This is the owner's son that makes the concentrate. In early October 2020, he got acute liver failure. He was drinking the Real Water that he was making, and he got acute liver failure. And we think that was sometime in the time period October 5th to about October 10th. But in October 2020, they got dozens of calls from customers who got sick. It wasn't just Blaine Jones. People were calling over and over again, and you would think that a responsible company would do a product recall at that point, okay? They did not do that. They didn't even investigate these complaints. Like I said before, they had a number of prior incidents. Next, Shane. So, next. 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 I'm trying to get you lunch, ladies and gentlemen. So, this is Patty Converse. We thought we were going to get her live, but I'm not so sure of that. We might have to play her video demo. She was the receptionist at Real Water, okay? They hired her as the receptionist, and then 6 weeks later, they needed a quality control director. Quality control is a very important position in a bottling water plant. She had absolutely no experience whatsoever in quality control. And she's going to admit that she wasn't qualified for this position. She was a good receptionist, but she wasn't qualified to be a quality control director. Next. And she was told to address these complaints by giving the customers free water. That was the solution here. Then I'm going to have another person coming from Real Water. This is Mr. Desitil. As you can kind of tell from his look there, he's a veteran, retired veteran. So he started working in Real Water in 2017. Ms. Converse was shortly before that. She was 15, 16. Then he came in, and they held him out as the quality control director. They printed cards saying that he was the quality control director, but they never told him he was the quality control director. Okay? He wasn't told he was the quality control director. He thought he was just a production manager. All right? He wasn't told about any of these prior complaints, and we're going to show you, again, some from 2014, a couple from here in Nevada in 2017 and 18. And he's going to tell you that if he had known about these prior incidents, he would have stopped the production line and investigated. But he didn't know about them, so that wasn't done. Next, please. The next witness who's going to testify is Blaine Jones. And I think I can get through this part. It might take a little longer than 3 minutes, but we'll try. So again, I told you that he got acute liver failure, okay? I don't want there to be any doubt in anybody's mind whatsoever that the executive vice president got acute liver failure in October of 2020. So this is the description of his injury in his own words. In his own words. Go ahead.
The pain, confusion, and fear I have learned about acute liver failure and hepatitis over the last few weeks invokes the old phrase, I wouldn't wish it on my worst enemy.
Okay, so basically you started getting sick that afternoon, right?
Correct.
And you said, quote, nausea came over me that night, unquote. Do you remember that?
Yes.
And in the morning, you had what you thought was, quote, food poisoning, unquote, right?
That's what it initially felt like, yes.
Okay. Skipping over a paragraph, it says, quote, next time I remember being wheeled down the hall into a room with a doctor. Over the next few hours, I was getting IV fluids. So next, the doctor told me my liver was shutting down in the next few days.
Okay, so what I'm reading from is he posted a GoFundMe describing everything. So I'm just reading him his account from the GoFundMe page, and that's going to be evidence. You'll see what he said about his injury. So his liver was shutting down. He was originally hospitalized in Utah, but then his father, Brent Jones again, went up to Utah, got him, brought him down here to Clark County Hospital. And he got in the Clark County Hospital, and he got worse. He got worse. All right, so he was counseled about having a liver transplant. Ultimately, he didn't have to have it. The big point here, I think, is that this happened in early October 2020. He had this injury. Next shape. Not the, skip over the, yeah, we don't need. I'm going to play the whole thing for you during the case, but I just want to establish the injury here. So, this is an answer that they gave to the FDA. The FDA started doing the investigation because remember the Utah doctor called up, and so they started doing the big investigation. So they asked Real Water, they said, well, when did you first start getting complaints? Okay? So instead of sending people free water, all of a sudden they were overwhelmed with these complaints. They assigned a production manager, Anthony Brown. These are the answers to the FDA. Okay? This is what Real Water wrote and gave to the FDA. So during the period October 15th through November 15th, they started funneling all the complaints through one person because they had got 20 to 30 calls regarding odd tasting water. In addition to Blaine Jones getting sick with acute liver failure, being in the hospital, they had all these customers who reported being ill. And what do they do after that? They do a recall. They do any kind of public alert. Didn't do anything. Did absolutely nothing. And so let's take a look at this timeline. This is what the evidence is going to show. Next. So this is the date we believe Blaine Jones was first hospitalized in Utah. Next. This is, I showed you the answer to the FDA that had all the customer complaints. That's October 15th. Next. He posts the GoFundMe. Remember, I was using the GoFundMe of Blaine Jones to ask him questions. So then they had a meeting. Okay, we're going to bring one of the persons that was involved in the meeting in to testify to you. The lower level employees at Real Water approached management and they said, hey, all these people are getting sick. All these people are getting sick. You even got sick. We have to do a product recall. And what was management's response? Nothing. Dead silence. No recall. No recall in October. No recall in November. No recall in December. No recall in January. No recall in February. Finally, in March, after the government is in the middle of its investigation, finally on March 16th, look at this. This is what, 5 months later? 5 months later, they issue the recall. And why is that important in this case? Shane? Next. These are the dates 3 of the plaintiffs were hospitalized. Christina, November 3rd. That's 19 days after they should have started the recall. Tina, 11/9. I think that's, what, 25 days after the recall. Jasmine, 11/15. That's almost a month after they should have started the recall. If they had just done a recall, these 3 people wouldn't have had to get sick. They would have had to have acute liver failure. Okay? And that's why we think Real Water, one of the reasons they're liable for punitive damages. Next, Shane.
I'm sorry, well,
Oh, okay. Mr. Parker wants lunch. So we will go to lunch because what Mr. Parker wants, he gets, right?
Okay. So what we need to do is I need to give you the recess admonishment, and counsel, I need to see all the jurors when I'm doing that, so
Oh, do you want me to take that down there?
just for
Sure.
during the.
I'm done.
So, ladies and gentlemen, now's the time for your lunch recess. First thing is you're going to need to, of course, leave those notebooks, please, on your chairs. During this recess, you are admonished not to talk or converse among yourselves with anyone else on any subject connected with the trial or the previous voir dire process. You must not read, watch, or listen to any report of or commentary on the trial or the prior voir dire process by any person or entity connected with the trial. Excuse me, person or entity connected with this trial by any medium of information, including without limitation, social media, text, tweets, newspapers, television, internet, radio. Anything I've not stated specifically is also included. Do not visit the scene or any of the events mentioned during the trial or the voir dire process. Do not undertake any research, experimentation, or investigation. Do not do any posting or communications on any social networking sites or anywhere else. Do not form or express any opinion on any subject in this case until it's fully and finally submitted to the time of jury deliberation. With that, hopefully you have a nice, relaxing lunch. Thank you so much. On the record, outside the presence of jury, I understand you all might be working on one other aspect, but really what we're trying to do is oftentimes it's helpful in trials if you all are playing video depositions and live live testimonies to provide a copy of, you want the transcript of the copy of the video data.
The transcript.
Pardon?
The transcript?
The transcript of the video depositions, yes, you want, okay. Is to provide, now we understand we have these sealed ones that are back in the back, our 10+ boxes of depositions. But if you are going to be doing witnesses, two things with regards to witnesses. One is give us a heads up the day before who are the potential witnesses, so we can go digging through those boxes to see which potential depositions might need to be open, published in open court versus having to bring all 10 boxes in here, we just don't have the space. The second thing is it's helpful, presumably you all already have an electronic version of those depositions at your respective law firms, is the day before, provide to the court reporter just the electronic copy, because it's helpful, and if you all are okay with it, if you're not, you need to let the court know. This is usually helpful for the transcriber, just to use that as a reference point. So that, say somebody's kind of talking at the same time you're playing the video dep, if they have a copy of the transcript handy, and you're saying pages in line anyway, they just have that as a reference point. Most attorneys have found that helpful in prior trials. Would you all like that in this trial? If so, you need to provide those electronic copies, and it can be done the day before for the witnesses that you anticipate, or if you want to do a whole grouping, these are ones for the week, here they are, we can do that as well.
Judge, I think we can do one step better, rather than give the whole transcript. I think we can print out the part we're playing with the question and answer on it, and just give them that. That way they don't have to wait for the whole transcript.
That's true. Right, and you have that electronic form, right?
Yes.
You anticipate, right, that's fine with the court. The only question I had about that is, and I don't want to segue into this because it could be a longer conversation, is I am not aware if you all were able to reach an agreement on some of the outstanding objections. And so it's fine if you give it in that somewhat longer form. And the worst comes to worst is they're not typing it all because you don't actually bring them in because there's an objection. So yes, that's a great plan, as long as that works. Does that work for Council Plano?
Yeah.
Council for Water? ETT?
Yes.
Okay. So then you just need to, when it's your turn, if you're a witness, whoever's got the electronic version of the depot section, just at least the day before, please provide it. It's best to provide it to you, Laura?
Yes.
Yeah, usually they go to the court recorder and she can forward it on to the transcriber. Okay?
If we could possibly get the Blaine
Blaine Jones, because since Blaine was played the part during the opening statement,
Thank you.
it would be helpful to have that. Okay?
And
Pepperman, you're standing up. Go ahead.
Yes, just to be clear, what Mr. Kemp was referring to, the cut that we plan to play at trial to present the witness's testimony, we have the transcript of just that portion of the video, not the whole video.
Perfect. And the only thing that would happen is if there's an objection to any section therein, then the transcriber would just have to insert objection, and then if the answer is not able to be provided, then they won't transcribe the objection. They will transcribe the objection, they will not transcribe the answer, is what I meant to say.
Correct, understood. Thank you.
Okay? Does that work for everybody? I heard it works for us.
Yes, Honorable Shorter Water, Joul.
Yes, it does, Your Honor, so I'd be happy to keep you.
Okay. So is there any demonstratives that you need the court's assistance with, or were you able to, while you were relaxing and enjoying your delicious lunches, you were able to resolve all issues?
I think we resolved most, Your Honor. In terms of, we need the court's assistance on one thing for sure. The customer complaints, Your Honor. My intention was to use a summary, the identical summary we used in the Gallagher case. And, there's some resistance because the court, it's my understanding based upon the motions in the that the court said we could use the written customer, we could use customer complaints, as long as they were written customer complaints. We couldn't use the FAM neighbor issue. But I thought we could use or create, if we did a summary of the customer complaints that we have related to real water. And so we just need some direction, clear, Your Honor.
So you're talking about an opening statement?
Yes, Your Honor. And I can just give you exactly what I'm looking at, Your Honor, if this would be helpful.
That would be helpful.
I've given it to everyone else.
Okay, so who's addressing, I don't think as much. Okay, I see Mr. Love standing up, go ahead, please.
Your Honor, Mark Love for Real Water. Yeah, I mean, our objection to this isn't just that it's hearsay and most of these complaints are unrelated to hydrazine, but these aren't the actual complaints. Council has basically summarized them, and so our position is their projected summary of what's in the complaints and Real Water's response to the complaints is argument.
Okay, hold on a second, let's do two different things. One, I'm getting to the court's actual order. But you can appreciate there's a lot of them, so it's gonna take me a sec to. Okay. Okay, so referencing plaintiff's motion eliminating number 19 to include testimony and arguments regarding purported lack of injury claims and lawsuits, or are you, there were some other ones that were in the Real Water, just bless you.
You know, I think I had it as our Real Water's motions 9 and 10.
Sure, like I said, those issues we're discussing a couple different ones, that's why I want to make sure we're. Second. Okay. Deferred until properly presented to the court, so you're properly presenting it to the court. Now, the court did not have an affirmative ruling on that yet, so. And consistent therewith, 10 says that same language, okay, so. And then in plaintiff's motion eliminate number 19, that I previously referenced. Okay. History, okay. Well, actually, that one's already been taken care of because of the history issue we've already gone through. Okay, so let's walk through these couple of examples. So which, are these all written complaints, Mr. Parker, or not?
I believe those are all written complaints. In fact, they're business records of Real Water.
Well, and that's where I was gonna go to next. Are they? Because the issue was notice, and so the
Right.
court's ruling was with regards to notice of complaints, which,
And Your Honor, these are not the actual customer complaints. These are counsel's summary of them.
okay,
And so our position, not only, you know, we have the hearsay objection as to the actual complaints, but also the use of the complaints in this format with their discussion about them is hard.
okay. Are any of these chevrons, the chevrons that were an issue about whether or not they were Terrible Herbst chevrons? Do I have that issue, or are those chevrons all Terrible Herbst chevrons?
There are two parts of that answer. There is one complaint on fuzzy water that is at a Terrible Herbst location. The others are not. And the single one that was at the Terrible Herbst location does not involve a complaint to Terrible Herbst. It's a complaint to Real Water.
Okay, so the Chevron gas station Buffalo Flamingo that says something fuzzy at the bottom, that's.
I'm gonna verify that, but yes, I believe so, because it's the one with the fuzzy in the bottom. But I'll find that in just a minute.
So, Councilor Plante, do you concur that these are not the actual complaints? These are a summary prepared by somebody for purposes of this litigation?
Your Honor, I believe the furthest right column, maybe this is summary, but I believe these are actually the complaints the Real Water's opinion of the complaint, and it's our summary as opposed to putting up, I think, 21 complaints, which the rules allow you to use summaries as long as the actual source documentation has been produced and discovered. This is their business records, it's their source materials. We compile them into a form that can be used easily and very open.
But here's the challenge. The responses are your own interpretations, right? Those are not exact quotes from the documents. Is that correct or incorrect?
For some reason, Your Honor, I think that's incorrect. I thought that was their responses, but I can check again. It was my belief that during the meet and confer on this topic, that there were no objections in terms of hearsay.
I'm sorry, I heard Mr. Love just say a moment ago that it was counsel's
We
interpretation.
do have hearsay objections. We did make note of what the court's ruling was on motions in limine 9 and 10, but we did indicate we felt that these were hearsay. If you read that, they're out of court statements.
Your Honor, they're Real Water business records.
Yeah, but the court's already ruled on that. I mean,
You ruled on non-written complaints, Your Honor, customer complaints. These are written customer complaints received by Real Water in Real Water's production.
so here's what the court's going to do. You can state them, but you can't use these slides as being physical slides shown to the jury during opening statement. You can reference the date and time, and that it's a complaint, and the complaint says to wit, maybe you'll get the actual language, later on in the trial or something like that. But the concern is that when these slides are shown the way that these are, is, well, A, for the issue of the ET&T, which was previously discussed by the court, and you all are going to confirm what chevrons were not owned by ETT, is how these look like they went to Terrible's. That's one issue. The independent issue is the summary is not exactly how they are presented, so they're not the notice of the actual customer complaint. So they could be viewed as argument rather than as opening statement the facts are going to show. And third is hearsay. By the way, some of these, just to let you know, like your number 7 says photos show retail bottle under store. I'm not sure what the photos show retail bottle store, and you've got some that are outside of Nevada too. Do you see the one you have in Gilroy, California?
I'm sorry, Your Honor, which one are you looking at?
Okay, sorry.
Which
I'm looking at, okay, let's go specifics. Your number 7, 52314, Cynthia Masson, under the section that says store, it says photos show retail bottle. I'm looking at the third column from the right.
I am as well, Your Honor.
See, it says photos show retail bottle.
I gave you my copy, so I got to.
Oh, I'm sorry, here, get your copy back, okay.
If I could.
I know my couple of issues, so feel free to take your copy back.
Okay, thank you.
If you look on the second page, number 7, you'll see, it looks like your third column, right? See the column that
I
says
do.
store, but see on that one it says photos show bottle.
It does, Your Honor.
Okay, then you've got another one that's Gilroy, California. So that's why the court is going to find some challenges with each of those slides and the accuracy with regards to what would be relevant for this case
Sure.
within the community. A, for the Gilroy issue, B, for the ET&T versus the real water complaint, and C, for the fact that down in their store, please only show me that says something of a picture of a bottle, so that way the fair analysis would be say that you can give the notice provision for purposes of your opening by giving a verbal statement, but not showing those actual slides.
Sounds great, Your Honor. Thank you.
Counsel, for real water, do you need to be further heard on that?
Nothing further.
Okay, counsel for plaintiffs, do you need to be further heard on that?
Not on this subject, Your Honor.
Okay, ETT, I didn't see you jump in on this one, other than the one question on the Chevron, but since he's verbally going to say them, does that address any issues you have, or do you have a different issue?
It does, and to just answer, you had asked me about the location, that was the location of that complaint.
The fuzzy one in Flamingo
Fuzzy was, yes.
is a Terrible Herbst Chevron?
It is, it's unrelated to liver, it's just fuzzy only, but it is at Flamingo. You had asked me specifically if it was the one at Flamingo and Buffalo, and it was.
Okay, so, but has the court addressed any concerns you had with regards to those being shown as so they're not going to be shown as demonstrative slides, but counsel can represent, if he has a good faith belief that, these are customer complaints for a notice provision, as long as he accurately states who they are to.
Yes, and he has already stated that they are to real water, so I don't have an objection, Your Honor. Thank you for
Okay, that takes care of that. Was there any other demonstrative issues that you need the court to address?
Yes, Your Honor.
Go ahead, please.
There is a timeline that we have one issue with. I think we've resolved it, but
That was the chronology issue, motion eliminating concept, or different?
I don't know, this one was actually addressed specifically on in the motion menu.
Okay, go ahead. What's the issue? Go ahead, please.
So the issue, I believe, is that ETT would not like you to refer to any court determinations based on the 1220 decision of the court relative to Terrible Herbst late identification of witnesses. This is the first motion, not this most recent motion strike. But when Terrible Herbst failed to identify witnesses and documents, and the court made its decision on December 20th. I have that as a part of my timeline. Mr. Boho preferred that court determination not be revealed to the
Okay,
jury.
let's go directly to the court's order in that regard. The court's order was dated January 17th, to memorialize the oral statements. Oral ruling from the bench on the 20th. Let me put a second to go back. Is that what you're referencing?
I believe so, Your Honor. Pleasure.
Do you mind if I look at the timeline with you? I have it.
Sure.
Okay. So if you're referencing order granting in part, denying in part, and deferring in part plaintiff's motion to strike ETT 1 LLC DBA Terrible Herbst answer or for lesser appropriate sanctions, that order, I got the order, I don't think the notice of entry of order handy, but
I got you.
1/17/2024 is the actual order. And what's the issue? Go ahead, please.
So the timeline has on it, the court finds that Terrible Herbst failed to produce documents timely and identifies witnesses, etc. Again, the court granted plaintiff's motion with regard to this. I don't think that the actions of the court and the orders of the court are appropriate for an opening statement. It seems to me that we stay with the facts in the case as opposed to rulings of court for opening statement.
And the court's going to cite paragraph 32 of its order. Paragraph 32 of said order says, as to the request for a curative statement regarding discovery failures, the court defers this request for such sanction until the parties have been able to draft statement and it is before the court to review. So since the parties have not drafted said statement for anything for the court to review, then you can't utilize what is, quote, the court's ruling with regards to that. You have to stick to the standard of an opening statement from a factual basis, okay? Because this gave you an opportunity if you wanted the court to look at it. Paragraph 32, nobody provided the court anything, so I don't. Would that be consistent with paragraph 32?
So, you know, one other point on,
Sure.
on that, if I could. The reason why the timing is somewhat important, and I don't have to mention that the court made a finding.
Isn't that the issue that you don't want to say the court made a finding?
Yes, I don't think the actions of the court, the dates that the things were filed, or actions of the court are for opening statements.
Right, I think you all might be on the same page as long as you delete the court found, or
Good
words to that effect. Is that correct, counsel, for ETT?
I learned, I'm sorry, I'm a little leery unless I know what exactly it is counsel is
Fair enough.
intending to say.
Fair enough. Okay, so this court's ruling is, paragraph 32 clearly said if you wanted to say something about a court ruling, you had to provide the court the proposed curative. Nobody's provided it, so you can't say it's court ruling. To the extent, but the court's not precluding in general chronological aspects of the case, but therein lies maybe a gray area that you might want to spend a moment with opposing counsel and see if you might want to work out said gray area.
So my point would be, and this is something really to address
Sure.
the comments made during voir dire as to admissions of responsibility. It can't be used as a sword and shield. You can't say it to try to endear some type of sympathy or some form of respect from the
Remember, there's a
jury.
motion eliminated that directly addresses whether you can say the stipulations.
Right, and we're not going to talk about the stipulation. We're going to say, this is when it was decided, or this is when they conceded. I'm not going to read the stipulation, I'm not going to say stipulation. But you can't parade in front of this jury, oh, we agreed that we're at fault. No, you didn't.
Okay.
You did last month, but you did it for the last 2.5 years. So you can't get the benefit of saying you conceded as if you conceded.
Hold on a second, let me make sure, you're talking about both real water and ETT?
Well, I'm talking about Mr. Boho right now.
No, the last
And
one seems
real
to be real.
Okay, folks, I
directly
can't have
real.
y'all both speaking at the same time, right? You're gonna have a very, very muddy record. You all want a nice, clear record, I'm sure. Particularly the various people that might be sitting in here or remotely for other purposes, it's perfectly fine, let's get you a clear record. So, do the court a favor, please. Please read the sentence that you're intending to, so that the court actually knows what you're asking the court to rule on, please.
Yes, Your Honor.
Either show it to me or read it to me, either is fine.
So I'm gonna tell you how I
Sure.
decided to change it based upon what the court has already said. Instead of saying the court finds the Terrible Herbst, oh, not that one. Real water concedes its water is defective and unreasonably dangerous, causing plaintiff's injuries. I had stipulation and order, reliability, and causation. I'm not gonna say those things at the end. But what I will say is that occurred on December 15, 2023. That's
That
it.
just says real water.
That's real water. Now, in terms of
Okay.
ETT, what I had was that the court granted plaintiff's motion for summary judgment as number one, which deals with the ETT. I'm not gonna say that.
Yeah, that's
All
all right.
I'm gonna say that as of 12/20/2023, ETT, or Terribles, has been found responsible.
Well, that's actually factually not correct, right?
I think that's the date.
No. That's the date of my ruling or pronouncement from the Bench Division of Family Services in Russ versus Clark County. And the problem is if you do the date of the actual order and notice of entry of order, that's triggered by you all submitting competing orders. Maybe not 100% timely. And then the court having the opportunity to address that when it could, don't know when you did your NEO. Therein lies probably not necessarily where you're going for on the pure procedural aspect.
Right.
I think you're going the conceptual aspect is you want to get across to the jury the fact that there was, quote, a finding and it was close to the time of trial.
Absolutely.
Challenge is how counsel can explain to the court that would be proper for opening statement. Who is going to be the witness and how is that evidence coming into the trial, right? The concept right with opening statement, sorry, the way I look at these oftentimes is, well, no one does this anymore. People used to say, the evidence will show X, the evidence will show Y. You all do it now in a lot more smoother transition. And some people do evidence show X, evidence show Y. But that's the global concept, right? Opening statement, evidence is going to show you have to have good faith belief. What evidence is going to come into this case that's going to show that ruling?
And Your Honor, I don't think we have to do it in the form of evidence. I think it's a law of the case at this point and is no different than indicating that a complaint was filed on this day and an answer was filed on this day. We can say those things because it's a matter of record in this case. You don't need to have someone get on the stand and actually confirm that. Same with this determination, especially since they, like I said before, I believe both defendants are trying to take advantage of this decision, be it their decision or the court's decision, that liability has already been imposed.
Yeah, but counsel, here's part of the issue, right? Part of the issue is you all requested that this court extend some of the deadlines, remember? Because you all were in the Gallagher trial. And so you asked the court to allow additional time for your motions, eliminating your dispositive motions, right? Which they were not in the Gallagher trial.
That's
So
right.
then you also asked that the court set all those motions, eliminate, and dispositive motions during that same 2-week time period so you could hear them all together versus having a few here, a few there. So that temporal component was created, A, to accommodate 2 of the 3 parties in this case. I'm saying that because ETT wasn't in Gallagher.
Right.
The second part was to accommodate the general concept of having a clarity, so you weren't ruling on, I wasn't ruling on something 1 week on 2, but then there was a related one that you wanted me to rule the week before, right? So that you all could merge them all together, come up with a listing of the order you wanted this court to hear them. You could do it all in a particular time frame to give enough people time for purposes of their 2.67 conference. And so I am hearing what you're saying, but the temporal component isn't truly an actual temporal component in this case because A, if those requests weren't made, I could have made that ruling earlier too, because you all wanted to do competing orders, meant the actual memorialization of the actual order, right, came apart. So I think you can get me some concept that doesn't get dates. Let's see what you want from a concept, right? But I'm real concerned about those dates because they're artificial in this case.
And Your Honor,
Do you understand what I'm saying?
I do. In terms of orders, notice of entry of orders, and scheduling of hearings, I totally understand what the court's saying. Because some of that dealt with, like you said, scheduling, it dealt with priorities based on the outstanding trial. Understood.
Which there's nothing negative there. I mean, we're
No,
just trying to
I
accommodate
didn't take it
this
as a
stuff, you know what I mean?
criticism.
So,
Yeah, I didn't take it as a criticism, you know. The point is, those decisions happened in the last 2 months. So even if I don't pinpoint a certain date on it,
but didn't you choose when you wanted to file your motion for partial summary judgment? Because technically you could have filed it in 2021, right? Or 2022 and had the court hear it. So, do you understand what I'm saying is, this decision is triggered by an action of plaintiff to put it before the court for the court to make the ruling. And you all could have chosen to done that at a variety of different times, and you chose to do it for the variety of different reasons you did. There's nothing negative or positive about that, but that would give a false impression to the jury that somehow ETT was waiting to have this done, when realistically, they only filed an opposition to your motion for summary judgment, right?
except that, let's take ETT since we're on ETT right now. ETT has contested it and is still contesting it up until today.
Well,
So-
who knows if they're still contested, I don't,
Up till today they were.
they
or
may
this
still
morning.
be, who knows?
Who knows? I don't want them to get the benefit of acting as if they conceded, stipulated, it was 2 years ago, when in fact, they're still, up until this morning, they were contesting the issue. And so they shouldn't, the impression shouldn't be left with the jury that they made this decision 2 years ago. That shouldn't be the impression, and that's the impression I think the jury has. That's number one. And in terms of Real Water could have conceded at any time over the last 2 years, but chose to do it in December. That's it. So it's not our timing in terms of motion practice that's
Well,
dictated.
two
when they
different
concede.
ones. Now remember, okay, we're talking two very different concepts, depending if you're talking ETT versus Real Water, right? ETT is by a ruling of the court that they opposed.
Right.
And they have a right to have opposed it, okay? The court doesn't agree with it, obviously, because I mean, there's rulings in order from this court's viewpoint saying, you know, that I should grant it, and then today's rehearing order. But the problem with that is, that's one issue. Real Waters, under your theory, you understand you filed your, sorry, I'm gonna have to go back to this, you filed your stipulation in October with regards to that in Gallagher, right?
October, yes.
Okay, and you know when your trial ended,
October 4th.
and you know when you filed your stipulation,
October 6th or something, I can't
October
remember.
4th or 6th, right, yeah. So, do you understand? So,
In that case, yeah.
if I use, and I'm not using that, obviously, I'm not ruling in another case, I'm just saying, by the party's own decisions that you might be busy in trial, or you might be preparing other motions, or you might be evaluating different things, may have a temporal component. Because if you recall in this case, Mr. Odou, remember, we called you in for hearing, the court asked about the scope, because you all told me about that you were stipulating in one, and there was, and I'm paraphrasing you, Mr. Odou, hopefully pretty close to it, he said, we have to check, you know, I think we might be doing the same in here, we need to check. Then Mr. Love, and he had a little conversation, and then it was like, stay tuned, court, okay? Well, new counsel coming in a case, and therefore wanting to evaluate with multiple counsel, can't be held against the underlying client, because there may need to be a coordination between counsel on a viewpoint. Same thing with ETT in a separate aspect. So I'm hearing what you're saying, I'm just not seeing how the opening statement from a facts of what the evidence are going to show, right, in an opening statement, how putting those dates in there is appropriate opening statement. So let me see what your alternative proposal is, and then I'll hear from opposing counsel.
I'm not married to the actual day in January or the actual day in December when all of this happened, Your Honor. But I am of the belief that the only way to not allow the jury to be misinformed or to believe that these stipulations or findings or concessions were done back in 2021 is to actually be able to say that it wasn't until, for example, Real Water, until the latter part of last year that the decision to concede liability was made. Or And then in terms of ETT, certainly it wasn't until this year, or, I'm sorry, latter part of last year, that it was determined that ETT was also responsible for the defective product and the injuries caused to the plaintiffs. And so I'm not married to the month, I'm not married to the date and within the month. But if we were to, by example, which we waived, I'll admit that up front, to read in the pleadings of both ETT and Real Water would have shown their denials of these allegations. And same with their second amended answer, their answer to our first amended complaint, our second amended complaint, all of those would have shown their continued denials, which is, again, part of the law of this case. So I don't believe that we have to have someone get up and say this, but, you know, if push came to shove, certainly I could get a representative of probably both companies to admit to it, but I don't think it's necessary, though. So I'm not married, and if the court has something, another suggestion, I'm fine with that.
I need to hear from the other parties, so which one might, okay, Mr. Boho, you're speaking first, ETT, go ahead, please. and then
Yeah, I
Mr.
think, as you stated, a party can't be prejudiced by a scheduling order and by a choice of time by counsel for the plaintiff who chose when to bring a motion, and then apparently try to use this as a sword here. So let's be very frank about what it appears to be. He wants to try to make an issue that things are happening later in the game when I don't see any relevance as to the time something was ordered here. Now, on the other hand, it seems in this case, we've talked, there's been discussion with the jury as to whether liability and causation are in question or not. And so I don't have an objection to a statement that the liability and causation are not in issue here. So they do hear that, and
I think Mr. Parker's point isn't, he's saying just, he thinks that that will give the defendants a benefit to say that. And he wants to ensure that it initially was contested. Is that correct, Mr. Parker?
That is definitely correct, John.
Okay, so you understand, I'm seeing you all as having two different issues.
yeah, yes, I didn't catch
Okay.
him trying to use that part. To me, it doesn't really matter one way or the other. The bottom line, the time he's trying to use the timing, whether he thinks I'm going to get a benefit the other way. The only issue is what is it that the jurors, as they sit there and listen to this evidence, what do they have to consider, and what issues have been taken from them? It's just that simple. All the rest about trying to get a benefit on time or not benefit on time is irrelevant.
Okay, so let me hear from Mr. Levin and then Mr. Moore question. Go ahead, Counsel.
Thank you, Your Honor. I mean, my issue is really the temporal one. I mean, for example, on behalf of Real Water, we conceded liability in the Gallagher case. There were certainly conversations between Mr. Odou and plaintiff's office about conceding liability in this group of cases. And so
you said in open court they wouldn't. Remember that, your first appearance?
well, we ended up doing it, but on
I'm just saying, you know.
on 4 of the 5 cases, we clearly were conceding liability and causation. And on one case, we're still evaluating, we were conceding liability, but we were evaluating the causation issue after our firm came on board. But I guess my point is, it's impossible to put a date on when an agreement was struck, because the date that the stipulation was signed was clearly many, many days after there was some oral agreement. And so our issue is having like a specific date in there. If Mr. Parker wants to say they admitted liability, you know, that's fine, we'll say that too. It's just, you know, being able to put like a specific date on it.
Once again, I think you're, from what Mr. Parker just said, that's a different issue. Here's a question for you. Would it meet the needs of the parties, and this court's not directing, this is just a question, to have some statement saying the court is instructing you that you can't take into account the fact, for either positive or negative, the fact that the only issues before the jury are the damages issues or something like that, so that it's being clear that it's coming as a court directive, that nobody gets any benefit or any negative aspect is taken. It's just these are the only issues that you're being asked to address, because that would be consistent with some of the voir dire questions, consistent with the concept that nobody benefits or has a disadvantage over the fact that people are conceding. And it also, and I was trying to pull up the motion eliminate, I thought it was AT&T's, it might have been the law, there was a motion eliminate. It specifically said that they didn't want the stipulation read, and I was gonna look at the exact language, if it was just straight reading the stipulation, or it was also the concept of the stipulation. And I was gonna, since I'm talking to you all, listening to everything, you appreciate, take a moment, because I had a heads up this was coming before me, so I was gonna quickly try and find that. And it's okay if Ms. Rojas wants to stand up, because she might have clarity on this issue, I think.
Thank you,
I'm
Your
not saying
Honor.
you do, if I'm hypothetically correct. Does anyone object, because,
No, Your Honor, I think you're just trying to flesh out everything.
yeah, you argued the motion.
Thank you, Your Honor. Valerie Rojas for ETT. We, I believe there was some discussion that Real Water wanted that not read to the jury, but we wanted it excluded altogether, obviously.
That's what I'm saying, I'd have to look at the actual language of the order to see exactly. I have a pretty good memory, folks, but a couple of lines in an order and hundreds of motions eliminate, okay, that really is last year, you know, I've kind of done a few things between then and now.
Yeah, I think
What do the court's concept of something like that, so that they're telling the jury they can't regard it one way or another, so there's no benefit or negative to either.
You know, I think I thought of another way to do it.
Sure, go ahead. What's your question?
And I'm not gonna address it, I'm not gonna address the slide, but I wanna get our openings done today. And this is something, the court said something that I think I can use during trial anyway, to get this point across without doing an opening. So I'm gonna,
Remember, it's not a court ruling, it was a question
No,
to see
no,
if that
I-
might meet the needs of the parties.
no, I get it, I think for purposes of trying to get the opening done, I think there's another way of getting it done during trial without having to mention it during the opening at this point in terms of time. So I won't worry about that.
Does that mean everybody's needs and we're moving on?
No, I prefer, Your Honor, exactly as you said, because that allows the jury to understand just what their job is in this case, since it is a different job than you have in most cases, where you think, gee, I wonder who's at fault here. And so at least this, in a neutral way, allows the jury to know what their job is. So we would ask for that.
Okay, now I'm going to ask, okay. So what I'm going to do is I'm going to defer that until it's your time for your opening to see if I should address it then, okay? Because in fairness, plaintiffs are right in the middle and he agreed to break for lunch for his opening, keeping the jury out there. We want to make sure you all have the same fair and adequate time. Remember, today is a hard and fast 4:45 p.m. Pacific time. In fairness to my team, we can't, you know what I mean? Can't keep doing the overtime issues, which some aren't getting, okay? So we need to make sure we get that taken care of. So, counsel for plaintiff, I understand you're not going to mention a court order or a temporal component of when concessions or orders are, and so there's no issue for the court to decide, is that correct?
That is correct, Your Honor.
Okay, so for right now, we see it's moving forward. If somebody wants to bring it up when it's closer to their opening, then you can put it on your checklist to bring to the court's attention, okay?
And I don't think there's any other objections to my opening documents, I don't believe, Your Honor.
Okay, so we all good? Should the marshal bring the jury panel in?
Your Honor, I apologize.
Bless you.
We need to have one short sidebar for a sensitive issue that's come up. If we could just approach for it.
Approach, okay, let's find out what this one is, okay?